I have said many times that Kyle Rittenhouse is probably on the hook for the minor possession charge. And I base this on an interpretation of a certain subsection of the Wisconsin statutes that I think that the state was going to run with. I think the state is really going to want to charge Kyle with this minor possession and make it stick. And so when I was reading the Wisconsin statutes in the past, I had a certain interpretation of the law that I think was wrong. Kyle may be in better shape with the minor possession charge than I originally thought. And this was brought to my attention by a Twitter follower of mine named Running Dog X. And he straightened me out on a thing or two. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
Okay, so let's take a look and see if we can now hash through this minor possession charge line by line. Now let's see what we can come up with. Okay, so this is it. This is where it starts, section 948.60. Now I'm trying to make this thing as simple as I can, so I've taken some liberties here, but I don't think anything that I have done here is going to change the nature of the law. So it reads, Kyle Rittenhouse's freedom to possess a weapon the night of the Kenosha shootings poses legal questions that leaves even seasoned lawyers struggling to plow through the morass of Boolean tangles and link spaghetti. Now, Boolean tangles, that's all those ands and ors that you have to be very careful about. And the link spaghetti are these links that circle around on themselves. And so it's constantly asking you to, it's constantly referring to subsections and stuff. And you got to go through all that. On its surface, the law governing minor possession appears clear-cut. And so let's go ahead and read this. This is subsection 2A. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. Pretty clear. At this point, the anti-Kyles exchange high fives and go their merry way. But to paraphrase an old adage, the devil is in the exception. This exception appears in the form of subsection C, which I will trim and demystify without the loss of accuracy as section 2C. The ban on Kyle possessing his rifle that we just read only applies if he has violated section 941.28 or was not in compliance with subsection 29.304 and 29.593. Now, we can ignore concerns over subsection 941.28. It doesn't apply to Kyle at all. This leaves us with a simpler statute to examine. Possession of a dangerous weapon by a person under 18. The ban on Kyle possessing his rifle only applies if he was not in compliance with subsection 29.304 and 29.593. My emphasis. And what's important here is the mention of the word and. As a Boolean operator, the conjunction and would seem to strengthen the state's case for a misdemeanor charge, for it establishes two conditions that Kyle must meet concomitantly, not just one. However, it might serve as Kyle's salvation because Kyle's attorney claims that 1. Subsection 29.304 does not apply to Kyle, and it clearly does not. It's because of the age deal. We'll show you in a minute. And 2, subsection 29.593 applies only to those actively engaged in hunting and not just merely possessing a rifle. On the flip side, anti-Kyles want subsection 29.593 to apply to not only hunting, but possession as well. So it really comes down to section 29.593. Does it apply to only those who are actively engaged in hunting, or does it apply to everyone? And by everyone, I'm referring to minors. Okay, so we take this one step at a time here. Subsection 29.304. Almost everyone has ignored the impact of subsection 29.304 because it only applies to minors 16 and under. The impact of subsection 29.304, however, lies not in its applications to Kyle's situation, but rather its ability to interpret subsection 29.593. We haven't read 29.593 yet, but we will. There are three age categories discussed in subsection 29.304. We will focus on ages 14 through 16. First, let us examine subsection A, which I have demystified slightly. Okay, so read this, 29.304A, restrictions on hunting, and I'm going to emphasize hunting here. No person of age 14 through 16 may hunt unless he or she is accompanied by an adult or is issued a certificate of accomplishment. And it reads on here, this certificate of accomplishment states that he or she successfully completed the course of instruction under the Hunter Education Program, and blah, blah, blah. By the way, I'm saying adult. It's a little bit longer than that. It's parent or guardian or somebody designated as a parent or guardian. I simplified that to adult to save time for brevity. Okay, so at this point, we should note the following. The Boolean or allows a minor to hunt by having either A, a parent or a guardian with them, or B, earning a certificate of accomplishment. Although seemingly innocuous, we need to keep an eye on stipulation A, and that is a parent or a guardian accompanying them. The certificate of accomplishment as a means of securing the privilege to hunt appears in this statute. And so we can go up and we can see it right here. It's boldface, issued a certificate of accomplishment. The prepositional phrase for hunting approval does not appear in the title of the certificate of accomplishment. So it doesn't say is issued a certificate of accomplishment for hunting approval. It just says certificate of accomplishment. And I did look it up. The language in subsection 29.591, subsection 4, that describes the purpose of the certificate of accomplishment specifically refers to hunting. However, it is not called a certificate of accomplishment for hunting approval. Now, if your head's spinning yet, it's going to get a little bit deeper here. The above, those stipulations that I've just read, concern only hunting. Section 29.304B, however, refers to the privilege of possessing a rifle and not just hunting with it. And I use the word freedom. I think that I would use privilege just to keep one more nitpicky thing out of the mix. Okay, so what does this section B say? Restrictions on possession or control of a firearm. No person 14 years of age or older, but under 16, may have in his or her possession or control any firearm unless he or she is accompanied by an adult, is enrolled in the course of instruction under the Hunter Education Program, and is carrying the firearm in a case, and there's some more stipulations about safety and how they transport it, is issued a certificate of accomplishment that states that he or she successfully completed the course of instruction under the Hunter Education Program, and so on. Okay, so we should note the following. Section 29.304 clearly distinguishes hunting from possessing. So in other words, the Wisconsin State Legislature clearly makes a delineation between hunting and possessing, therefore demanding that we treat the two actions as distinct. The requirements to earn the privilege to hunt for a minor mirror closely the privilege to possess a rifle, with the added option that a minor can possess a rifle if he or she is enrolled in a special course for hunters. So in other words, the restrictions on possessing are not more stringent than for hunting. They're actually looser, although not by much. Now, let's take a look at subsection 29.593. Now, let us examine the second requirement for a minor to possess a rifle, namely subsection 29.593, and the emphasis here is mine. It states, requirement for certificate of accomplishment to obtain hunting approval. Now remember, in section 29.304, the phrase to obtain hunting approval did not appear. It appears here. It's also not a part of the title of the certificate. Except as provided under subsections 2, 2M, and 3 in section 29.592, no person born on or after January 1st, 1973, may obtain any approval authorizing hunting unless the person is issued a certificate of accomplishment under section 29.591. And the section 29.591 just describes the certificate itself. A few points surface. The insertion of to obtain hunting approval appears in the title of the subsection, but not explicitly in the name of the certificate. So they inserted to obtain hunting approval explicitly. This law was first drafted in 1984 and included the January 1st, 1973 date, which meant that the law initially applied to children at least 12 years old, because the law would not have taken effect the following year, and would remain applicable to those 12 years of age or older from that point on. Okay, so at this point we want to remind ourselves, the anti-Kyles want 29.593 to apply to not only hunting, but possession as well. So let's take a look at some arguments here. Section 29.304 specifically allows for a minor to possess a rifle without the requirement of a certification of accomplishment under certain circumstances, for example, accompanied by an adult. However, if subsection 29.593 applies to all activities, not just hunting, that would negate the adult accompaniment option for not only hunting but possession as well, relegating those options to no effect. In short, subsection 29.304 would allow minors to possess a firearm even without a certificate of accomplishment. Subsection 29.593 would disallow such a privilege. Such contradictions do appear in statutes from time to time, although they signal potential misinterpretations of the law. So we can ask at this point, what purpose did subsection 29.593 serve? It appears that the legislature in 1984 changed the rules for hunting, requiring that minors 12 and under at that time who want to go hunting must first earn a certificate of accomplishment. Perhaps a tragic hunting accident spurred the change in the law. Prior to that year, those that wanted to go hunting could if they were accompanied by an adult. Note, however, and this is really critical, and we're referring back to 1984, the legislature could have easily mandated this restriction, and that is the requirement that they have a certificate of accomplishment, to apply to those who want to possess a rifle as well, if it had wished but chose otherwise. Okay, so here is the deal. Wisconsin law allowed minors to possess a rifle under two conditions. They could be accompanied by an adult, or they could have a certificate of accomplishment. And the same thing applied to hunting. They could be accompanied by an adult, or they could have a certificate of accomplishment. In 1984, the legislature changes the law. They basically say that if you want to go hunting, you must have a certificate of accomplishment. Being accompanied by an adult no longer is enough. Now, if they wanted to change the law for possession of a firearm, they would have done so at that time. They chose not to. Furthermore, they inserted the phrase for hunting purposes in the title of the statute. So let me read. The fact that this section is titled Requirement for Certificate of Accomplishment to Obtain Hunting Approval discloses the true intention of the change in the law, to ensure that those who go hunting possess reasonable hunting skills and safety practices. Because hunting involves the actual firing of a weapon, or at least you go out on that day with the intent of firing the weapon, whereas possession involves only the transportation of the weapon from point A to point B, we can see why legislators chose to place harsher restrictions on hunting than possession. So, does the fact that the legislature chose not to change a law in such an obvious fashion have any legal bearing on its interpretation? So, in other words, the legislature could have changed the law to reflect possession as well as hunting, but chose not to, and such a change would have been obvious. If you're looking back at your statute and you want to modify that, why wouldn't they have done it for both hunting and possession? And the fact that such a change was obvious and they chose not to do so, is there any basis for interpreting the law along those lines? And the answer is yes. As I discussed in another video, the Wisconsin Supreme Court used the fact that the legislature chose not to allow felony expungements to restore gun rights, when in fact it could have done so to deny an ex-felon his right to possess a firearm. So if you remember, this is a video I did some time back. The question was, does felony expungement allow ex-felons to possess firearms? The deal was that the old law for the restoration of rights depended on federal law. In other words, they modeled it on federal law. The federal law changed, and the federal law allowed a felony expungement to restore gun rights. Wisconsin never did change its law accordingly and left it alone. And the fact that they had ample opportunities to change the law and chose not to do so implied that the legislature had no intention of changing the law, and that therefore the proper interpretation of the law was that you needed a governor's pardon to restore your gun rights. If anybody wants to see the case law around that or the previous video, let me know and I'll post a link to it. The viewer might ask, well, does subsection 29.304 not require that Kyle be accompanied by an adult? However, we must remember that subsection 29.304 only specifies requirements for minors up to the age of 16. At 17 years of age, subsection 29.304 alone places no restriction on Kyle's privilege to possess a firearm. In the absence of such legislation, we can only assume that no such restrictions exist unless specified somewhere else in the law, and it isn't specified anywhere. By the way, I did go through 29.593. I walked through the actual revisions of the law to see if I could find some reason why it was enacted in the first place, some hint as to its purpose. And as you can see, I put the work in, but there's nothing here that really tells me anything. So I did try to investigate that angle. What is the result? Kyle, legally allowed to possess the rifle that night. And I said before that he was not, or at least I said that the state would likely not be amenable to that legal conclusion. In my opinion, this is pretty cut and dry now. So I have changed my mind. What does this all mean? Well, I admit, I think I misinterpreted the law. I think Kyle Rittenhouse is in good shape as far as minor possession is concerned. I just really don't see any alternative explanation for this. However, if you have one, by all means, point me to where I'm wrong. More than happy to correct a record. Like my video and subscribe to my channel.